Implementation of directives. It would not be an easy task to survey the progress made by government of Union and states of implementing such as the large number of directives over a period of over 7 decades since the promulgation of the Constitution. Nevertheless, brief references some of the outstanding achievement may be made order the illustrated that the directives have not been taken the government in power. Pious homilies as the suppose many when they are engrafted in the Constitution. The greatest progress is carrying out the directives has been palace as the regard Article 39B, which directs that state should ensure that the ownership and control of the material resources of the community are so distributed as best we serve common good. The distribution of the largesse of the agrarian community country like India, the main item in material resources is no doubt agriculture. Since the time of permanent settlement, the important sources of wealth had been largely appropriated by the group of hereditary proprietors and other intermediaries. Now, various different parts of the soil or part of the country, such as the Zamindar, Jagirdar, Inamdar, etc., while the actual tiller of the soil were being impoverished by the oppression of the various economic forces apart from the high rents and the exploitation by the intermediate. The Planning Commission and its first plan therefore recommended an abolition of the intermediate and so on bring the tillers of soil a direct relationship with the state. The reform has by the time has been carried out almost completely throughout the India. Side by side with this, legislation has been undertaken in many of the states for the improvement of condition of the cultivators as regards security for the tenure, fair rents, and the like, as the order of prevent as the concentration of land holding among the state and actual cultivators. Legislature has been enacted in many of state fixing the ceiling, that is to say a maximum area of land which may be held by an individual owner. It is already been stated how these reforms have been facilitated by amending of the Constitution to shield this law challenge in the courts. A large number of laws has been enacted to implement directives of Article 40 to organize village panchayat in Indo them the power of self-government. It stated that there is 2,27,698 Gram Panchayat, 5,906 intermediate tiers and 474 Zilla Panchayat in the country. Though the constitution and functioning of the panchayats vary according to of the different state acts, generally speaking, the panchayat elected by the entire adult population of the village have been endowed with the powers of civic administration such as the medical relief, maintenance of village roads, street tanks and wells, provision of primary education, sanitation and the like. Besides the civic function, the panchayat has also exercised judicial power. Legal practitioner has excluded from these village tribunals through owning the lack of proper education, narrow-mindedness and sectional interest in the rural area. The system of panchayat administration is still under controversy. After the Constitution 73rd and 74 Amendment Act, almost all states have enacted laws vesting various degrees of powers of self-government in the hand of panchayat. For the promotion of cottage industry, Article 43, which is the state subject to central government, has established several boards to help the state government in the matter of finance, marketing and alike. These are All India Khadi and Village Industries Board, All India Handicraft Board, All India Handloom Board, All Small Scale Industries Board, Silk Road, Coir Board. Besides, the National Small Industries Corporation has been set certain statutory function and the Khadi and Village Industries Commission has been set up for the development of the Khadi and Village Industries. Legislation and compulsory education. Article 45 has been enacted in most of states and 3 union territories. For the rising of standard living, Article 47, particularly of the rural population in the Government of India launched in its Community Development Project in 1952. Later, the integral part of development program IRDP 1978-79, National Rural Employment Program NREP, Rural Landless Employment Guarantee Program RLEGP, Drought Prone Area Program DPAP, Deserts Development Program DDP, and some other schemes were launched. Through the legislation relating to prohibition intoxicating drinks and drugs, Article 47 had taken place in some of the provinces long before the Constitution came into being. Not such the effective work has been done until to pursuance in the directives of the Constitution. The Planning Commission took up the matter and drew up a comprehensive scheme through the Prohibition Inquiry Committee. Since then, the prohibition has been introduced in several states in whole or in parts, though the state's paucity of it financial resources in the primary reason for the failure of fully implement and directives so far. It would be only candid to record that ultimately failure of the people to imbibe the Gandhian ideal of life at the back of the failure. The spread of the malady of intoxication amongst the younger generation since the independence, in fact, alarming. It should be pointed out the fresh impetus was given to program of the prohibition by the Janata Prime Minister Mr. Desai, staunch advocate of Gandhian philosophy in the matter. In the separation of the executive from the judiciary, Article 50, the slow progress and diverse method in the various states has been replaced by a uniform system by the union legislation in the shape of Criminal Procedure Code 1973, which is the place function of judicial trial in the hand of judicial magistrate, who is the member of judiciary and are under the complete control of the high courts. Besides the directives contain the part 4th, there are certain these directives addressed to the state other parts of constitution. Those the directives are the non-justiciable. These are Article 350A enjoy every state, every local authority within the state provide the adequate facilities for the instruction of the mother tongue at the primary stage of education. The children belonging to linguistic minority groups. Article 351 enjoys the union of promote spread the Hindi language and develop it so that is may serve the medium expression at all the elements of cosmic culture of India. The Article 335 enjoys the claim of members of scheduled caste and the scheduled tribes shall be taken into consideration constantly with the maintenance of efficiency of administration in the making appointment to the services post of connection with the affairs of the Union of State. Though the directives contain Article 335, 350A and 351 are not included in Part 4, the Court may give similar attention to them the application of the principle that all parts of Constitution should be read together.